Hi everybody. So I was going to say sorry that we're late, but I think the conference is running a little bit early, so I'm not going to blame us. I just want to start off with an acknowledgement that we made on the lands of the Wurundjeri people of the Kulin Nation and pay respect to their elders past and present. I extend that respect to all Aboriginal and Torres Strait Islander people here with us today. Sovereignty has never been ceded. This always was and always will be Aboriginal land. Today we will be speaking about police and the criminal law, and we must ground that discussion in the understanding that the police force in Australia were one of the main enforcers of colonisation and violence. Aboriginal and Torres Strait Islander people have been, since colonisation and still today, disproportionately targeted and harmed by various parts of the criminal legal system, and especially police. I want to also acknowledge that Aboriginal and Torres Strait Islander people have led the way in resisting police violence and systemic racism, and acknowledge their strength and resilience. I have the privilege of walking alongside our incredible colleagues and clients in that. I also want to give a content warning. This presentation will discuss police violence and references to Aboriginal people who have died in custody. So my name is Elle Triantafillou, and I'm currently acting as the managing lawyer of the Wirraway team, which is the Police and Prison Accountability team at the Victorian Aboriginal Legal Service. I'm joined by my colleague, Aunty Schoenfelder, a proud Wathaurong woman and the Family Support and Advocacy Officer in the Wirraway team, and by Dagher and Harry Williams, who are lawyers at Allens and co-coordinate the Police Accountability Clinic, a project run in cooperation between VALS and Allens. Thank you to the conference organisers for having us. It's a real privilege to speak here today. Today we will be speaking about the clinic as an example of a model for partnership that has the potential to achieve both individual and systemic outcomes for Aboriginal and Torres Strait Islander people harmed by police violence, misconduct and wrongdoing. I would like to start by setting the scene for our work, one which no doubt will be familiar to many in the room. Systemic racism in Victoria Police impacts Aboriginal communities every day and manifests itself in the way that Aboriginal people are over-policed, over-represented in police custody and underserved when they seek assistance. It is evident in police using force and racially profiling Aboriginal people. Systemic racism is the ways in which laws, policies and practices across agencies work together to produce a discriminatory outcome for racial or cultural groups. Continual over-policing leads to shamefully high incarceration rates for Aboriginal people, which were identified more than 30 years ago as the main driver for Aboriginal deaths in custody by Dick. Most recent data from the Racial Profiling Data Monitoring Project indicates that in 2023, Aboriginal people were 11 times more likely to be searched by Victoria Police than white people. A 2023 report by Dr. Tamar Hopkins and Gordana Popovic, commissioned by the Inner Melbourne Community Legal Centre, explored the impact of perceived race in the issuing of COVID-19 fines during 2020. They found that Victoria Police disproportionately targeted Aboriginal and Torres Strait Islander people during the pandemic, who were 2.5 times as likely as white people to be issued COVID fines. And this was particularly acute in certain locations. So for instance, in Mildura, it was 1 in 3 fines that were issued to Aboriginal people. And in Collingwood, for example, this was 1 in 5. I'm sure that to everybody in the room, these statistics are absolutely appalling, but perhaps not surprising. Compounding all of this, the police oversight system in Victoria fundamentally fails to hold police accountable and address institutional violence, corruption and misconduct. There are 2 main bodies that someone can make a complaint to. One of them is IBAC and the other is Victoria Police itself. As many in the room I'm sure would know, the system is broken and in practice there is no independent oversight. Complaints made by Aboriginal people are treated woefully by police. IBAC looked into this in 2022 and they found that about 98% of complaints were investigated by Victoria Police, and most of those were unsubstantiated. There's no practice for culturally appropriate handling of complaints, and while Aboriginal people come into contact more with police, they make fewer complaints about police misconduct. This isn't because police are doing the right thing, it's because of these extremely low rates of substantiation and a complete lack of trust in the system. A substantial proportion of complaint files indicated bias, a lack of impartiality, and poorly managed and identified conflicts of interest. And of the complaints IBAC looked at, almost half of the complaints were by Aboriginal people. Almost half of the complaints by Aboriginal people related to the use of force, and almost half were complaints involving children. And this is certainly what we see in our practice. Some of the most egregious examples of police violence that I've certainly seen has been directed towards Aboriginal children. I had one client who was 14 years old when he was bitten by a police dog after shoplifting, I think it was a pie from 7-Eleven. Another client, also 14 and living in residential care, ended up in hospital with head injuries after being arrested at a train station for throwing rocks. It's absolutely appalling examples. And the fact that these sorts of incidents are investigated by police is unacceptable. This is an issue that has been looked at across many arms and levels of government in countless inquiries, commissions, and in coronial inquests into black deaths in custody. Aboriginal communities, including VALS clients, ACOs, and the Aboriginal Justice Caucus, have consistently shared their experiences and proposed solutions as part of these inquiries and reviews and at the Yuruk Justice Commission. Indeed, it was at Yuruk that the Chief Commissioner of Police in Victoria, Shane Patton, apologised to the Victorian Aboriginal community. And in doing so, he acknowledged the systemic racism, racist attitudes and discriminatory actions that have gone undetected, unchecked, unpunished, or without appropriate sanctions. He acknowledged the harm caused across generations of Aboriginal families. Asked by Yuruk Commissioner Travis Lovett if he believed oversight of police would be strengthened if there was an independent investigation of police complaints, Patton said, "I do now." I think that's just really a testament to how important the work of the Truth-Telling Commission is. Patton said that if the Victorian government asked for his advice, he would flag that Victoria Police was open to implementing an external oversight body. He issued a statement of commitment responding to Yuruk and committing to delivering 79 actions by the end of 2025 in relation to monitoring and accountability, cultural and human rights capability and compliance, including to support any independent oversight body with investigations of complaints made by Aboriginal people. However, we are yet to see what impacts the statement of commitment will have, and we are yet to see any commitment from the Victorian government on an independent police oversight body, despite calls from the community. What we have seen is the Victorian government reneging on a promise to raise the age of criminal responsibility to 14, and the introduction of electronic monitoring as an option for children on bail. Shameful decisions which will continue to see Aboriginal children over-policed and over-incarcerated. Wirraway is a word which means challenge in Wurundjeri language, and our practice is committed to challenging these harmful and violent systems. We provide advice and representation to clients in police and prison accountability matters, including civil litigation. We also provide representation to the families of community members who have died or been killed in police or prison custody. One part of our practice, which we will be speaking about today, is the pro bono partnership we have with Allens, which was set up in late 2022. At the time, we were a very small team of just a couple of lawyers and a paralegal. The partnership has allowed us to greatly expand the scope of our work and ensure that Aboriginal and Torres Strait Islander clients can be represented by an Aboriginal legal service in these sorts of matters if they so wish. The VALS team has expanded. We're currently a team of 7 lawyers, 2 full-time paralegal roles, and Jo, our Family Support and Advocacy Officer, supported by Allens to run civil litigation and provide research support in police accountability matters. So due to our complete lack of faith in the police complaint system, our practice has moved away from making complaints to using civil litigation as a police accountability mechanism. Without going into the elements of each, there are civil actions available to clients against the police, as against the state, as vicariously liable for the actions of police when police act unlawfully. For example, if police use excessive force, like in the examples of my clients I mentioned earlier, or stop and search somebody without lawful grounds, then that person may be entitled to bring a claim in assault or battery against the police. If someone is unlawfully arrested, they may have a claim in false imprisonment. And if charges are brought with malice and without reasonable and probable cause, a person may have a claim in malicious prosecution. Sometimes we see this when police invent or trump up charges to hide their own misconduct. Harry, Caitlin and Jo will shortly speak to a case study that of a claim that we brought on behalf of a client recently. So on this next slide, I've just listed some of the avenues available to individuals and communities to hold police accountable. Some of them are, I guess, traditionally considered as non-legal avenues. I just really want to make the point that civil litigation is just one strategic lever for change amongst many, in addition to the continued advocacy and work of community over decades. To be effective, our work must be guided by community. I've listed a number of tools for change, and some of these we try to implement concurrently with our civil litigation work. Activism, advocacy, media and campaigns are a very important part of the picture. For instance, the decriminalisation of public intoxication, which occurred late last year, is impossible to speak about without referring to the horrific passing of Aunty Tanya Day in police custody and the tireless and staunch work of the Day family following. And recent changes to the Bail Act, which I understand will be discussed by some colleagues in further detail at another session at this conference, which are really a legacy of Veronica Nelson's family following her preventable death in prison after treatment described as cruel and inhumane by the coroner investigating her passing. I've listed truth-telling on the slide as well. So this may be journalism, art, literature, music, all of those things are really important, as well as the unflinching truths told by those in the community who gave evidence at URUC or other inquiries. And amplifying client voices and using a strengths-based approach. So our clients are strong and proud of their culture. We always try to bring in a human element and tell our clients' stories as a way to combat systemic racism. The stories told in public and legal spaces expose and counter the preconceptions that shape the dominant narratives behind the law. We're influenced by the Passing the Message stick paper written by Dr. Jackie Huggins and Larissa Baldwin-Roberts and others in that team. It discusses the issues with using a deficit-based framework when speaking of First Nations justice issues and the importance of shifting the focus onto unfair systems and the strength of Aboriginal and Torres Strait Islander people. I highly recommend reading these resources if you haven't already. A deficit frame is a focus on individuals and deficiencies. For example, descriptions of vulnerability, dysfunctionality and trauma without reference to systems that cause these things. So rather than use language focusing on deficits, criminal offending, drug addiction, which is how the court and police characterise our clients, instead we focus on their strengths, the humanity of the person, culpable systems, and the racism of those systems. It's important for us to act in a way that is trauma-informed and as culturally safe as possible. This means meeting clients where they're at, learning about intergenerational trauma, histories, cultural practices, finding out what is important to your client in a legal process which may be re-traumatising. As lawyers, it is our responsibility to do this, and we must always be learning. My clients and their families are experts in their matters and in their own lives, and it is my job to ensure their voices are elevated to be heard on the issues that matter to them. Listening and learning from clients, being willing to accept feedback and concerns, calling a spade, so pushing the issue of systemic racism and discrimination when those on the other side are reluctant to accept that characterisation, challenging established narratives and conceptions of events, being willing to accept some discomfort and being willing to be disliked in the process. So I've just listed some challenges that we face in our work, which I'll go through before I hand it over to Caitlin and Harry. Most of the claims that we run or are run in this space settle on a confidential basis. So information doesn't always make it into the public domain, and media generally want to see footage if they are to consider an incident newsworthy. And accessing footage, especially body-worn camera footage, has particular challenges. So body-worn camera footage is in its 7th year of use by police in Victoria, and the main supposed benefits of the widespread deployment of body-worn camera footage were meant to include enhanced transparency and accountability. However, it's very clear that in Victoria, body-worn cameras were never really meant to increase or promote police accountability. The legislative regime governing their use, so the Surveillance Devices Act and associated regulations, actively work against this purpose. Body-worn camera footage can be used for evidence in the course of criminal proceedings to prosecute crimes, but up until 2022 could not be used as evidence in civil proceedings against police that had themselves perpetrated crimes or acted unlawfully. So there was legislative change in 2022, and this was a really positive development, but there are still some barriers. So police take the view that civil proceedings have to be on foot before they'll release body-worn camera footage to you, and as lawyers, you really want to have a look at the body-worn camera footage to assess whether you can bring a claim or not and provide your client with some advice. Footage is not available through freedom of information in Victoria, and footage, if you make a complaint, footage can only be viewed at a police station. But as mentioned earlier, there are many legitimate reasons why somebody might not wish to make a complaint or indeed go down to a police station to view the footage of a traumatic incident with police present in that very room. And compensation doesn't always equal accountability. Accountability isn't achieved solely through civil litigation. As I mentioned before, it is one tool amongst many. And whilst compensation can be really helpful for people and it's an acknowledgement of wrongdoing, most of the time clients tell me they just don't want this to happen to anybody else again. I'll now pass over to Caitlin and Harry, who will run through how the clinic works in practice and provide a case study of one of our matters that settled recently. Thank you.
Thanks, Elle. So I'll just begin quickly by giving a bit of a more logistics run through on how a top-tier commercial law firm ends up working in partnership with VALS. Firstly, just to begin, the clinic started 2 years ago with very humble beginnings. Essentially, the VALS principal lawyer at the time reached out to our head of pro bono and community engagement, having heard of some of the past police powers work Alan's had done through other projects. So, for example, the Public Interest Advocacy Centre, which is now known as the Justice and Equity Centre, and just asked if Alan's would be interested in assisting VALS with similar work. We were interested, we scoped it out and started recruiting secondee lawyers. The partnership began with 1 or 2 small test matters and 5 or so secondee lawyers before expanding over time to what we now have a team of 50 plus secondee lawyers and a steady stream of matters coming through the partnership. We operate in pods of 3 people, where we have a senior lawyer supervising the matter and 2 juniors, one being a first or second year lawyer and the other a third or fourth, who are in charge of day-to-day management. What this looks like for us is that there's about 30 ongoing matters and 50 lawyers involved in the clinic. And we're considered, for all intents and purposes, secondees for the purposes of this clinic, instead of providing what would be more usual, which is like ad hoc assistance on different kind of legal research matters and existing VALS matters. So what that means is we're in charge of running a matter in full from start to finish. This means that We've all been trained to operate and use VALS as practice management system. We draft our correspondence. We conduct research as necessary. We brief counsel, and we're the primary contact point for the client. VALS then will review any final drafts of substantive correspondence and help us with analysis of prospects before we send anything out to the client. We also have scheduled fortnightly check-ins and a monthly file review where we can ask any questions as we go, as well as any ad hoc emails or calls we need along the way to fill in gaps or queries with VALS. Our lawyers report that there's a broad variety of things that they do on a day-to-day basis. Sometimes many weeks can go by with little or no action on a VALS file as we await something like an FOI decision or correspondence from Victoria Police. At other times, they're some of our most demanding matters as we assist to prepare pleadings, review evidence, and prepare material for mediation. But we've found the structure of 3 lawyers per matter assists to manage these ebbs and flows around our other work. The biggest advantage that we think we've achieved from involvement in this clinic with VALS is that we've really been able to increase VALS's capacity and allow for more matters to be investigated while ensuring that same level of high client care is maintained. And this expansion has not only allowed us to serve more clients, but also provided opportunities for conducting detailed research, testing novel points in FOI matters and similar, which we can then share with VALS lawyers for future work. And we've found these sorts of issues that we're able to assist with are ones that VALS doesn't always have time or capacity to deal with in detail, given internal resource and time constraints. So we've really been able to use our team to pursue what I would call these more kind of rabbit hole inquiries. In addition to those fortnightly catch-ups I mentioned earlier, which act as a means to keep up to date on matters run by Alan's secondees, it also provides opportunities for knowledge sharing. For example, a few months ago during one of these catch-ups, I was put in touch with a VALS lawyer who had encountered the same sort of FOI rejection scenario as a matter I was working on. We were then able to share knowledge, experience, relevant case law research, and things like that to avoid double handling and increase overall efficiency within the clinic.
Thanks, Caitlin. So the clinic's had some recent successes, and we wanted to run through a case study to sort of illustrate how the clinic works and what it's seeking to achieve. In keeping with the client's privacy and our obligations of confidentiality, we'll give a sort of de-identified case study. So this case involved allegations of unlawful arrest and misuse of force in the course of an arrest, in particular involving the use of tasers. As Elle sort of touched on, sadly, this is perhaps an all too common type of incident, illustrative of the systemic issues, but one that we could pursue in the clinic, partly due to the greater capacity that it has. So in terms of how the matter ran, the writ originating the claim was filed on the basis of the client's instructions about what occurred. Limitation period issues meant that we weren't able to gather evidence before the writ was originally filed. But subsequently, we engaged with VALS an extensive information gathering process. So there were FOI requests for the body-worn camera footage, CCTV, and contemporaneous reports of the incident and other material in order to assess liability, and then to gauge damages, requests for documents to the client's medical providers and people like that. The access request through FOI had mixed results. As Elle spoke about, body-worn camera footage tends not to be available, unfortunately, at the moment, but we were able to receive some contemporaneous police records. We then got expert evidence and briefed an expert medico-legal psychiatrist who assessed the client's condition and the impacts of the incident. On that basis, we could brief counsel to advise on prospects, and ultimately we were satisfied that there was a reasonable basis, together with the client's instructions, to file and serve a statement of claim. Once that proceeding was on foot, through the civil proceeding, we could access the body-worn camera footage, and that was used to enter a mediation in which the matter settled. As Elle sort of spoke about, I suppose, from the fact that Victoria Police were willing to enter a settlement at the mediation, it can be inferred that they acknowledged that there was a risk that their conduct had involved a misuse of force. The subsequent settlement negotiations were lengthy, as you can imagine, but important considerations in the process were ensuring that the client maintained the ability to make a complaint and try to seek sort of acknowledgement of wrongdoing through that avenue, ensuring that the client could make future claims and considering impacts on things like Centrelink benefits and how payments to Medicare would function and things like that. So that's one recent successful example that we've had, and as Caitlin says, there's many current matters ongoing. I think if we go forward a slide. Thanks. So from our perspective, involvement in this clinic is very different from our sort of day-to-day practice. And so it's been crucial, and it would be crucial, I think, for a similar clinic to address the potential gap in secondee lawyers' cultural competency. In our clinic, we've sought to do that in two ways. So the first has been quite extensive cultural capacity training to understand the basics around being a primary point of contact to clients and giving appropriate care. And secondly, when our matters become more complex and stressful, we have the support of VALS's in-house support officer, Jo. Jo will speak in a moment about her role, but we should just say that from our perspective, Jo's input has been crucial. We've felt to make clients feel more comfortable throughout what can otherwise be, as you can imagine, a stressful and, I suppose, unusual legal process, and to bridge the gap between the advice that we give and the client's needs. Having Jo available to provide assistance throughout our matters has allowed us to build trust, obtain instructions, and explain issues more easily. So in the case study I just mentioned, Jo was regularly on calls with the client before the mediation, attended the mediation in the client's hometown to provide support on the day, and then played a key role in explaining what was going on during the settlement negotiations and bringing the client along that journey. So we'll now pass on to Jo to discuss her reflections on the clinic and how she's sought to ensure that it provides appropriate support.
Hi everyone. I'm not used to speaking in this, so bear with me. My name is Joanne Schoenfelder. My mob is from Wathaurong down Geelong Way, and I'd like to acknowledge any elders and mob that we have here with us today. I'd also like to acknowledge my Samsung phone. No. Bless. I'd also like to acknowledge, again, give me 1 minute. Yeah, do you want to hold that?
Yeah, for sure.
It's shocking.
No worries.
Start again. Let's see. Thank you for your patience. I'd also like to acknowledge the hardship, the destruction, disrespect and the harm that our ancestors endured following colonisation. These devastating impacts are still evident and felt today. Hence, my role is to support and advocate for families going through the coronial process after losing a loved one through police or prison custody, and to provide support for clients in police accountability matters. I would also like to say that we stand in solidarity with community members who have come forward with complaints against police. Community members seek justice. And it's really hard if you're a black fella and the police have done something to you. Who do you speak to? What do you do? This is normalised. Through my own experience with community, with family, with friends, this happens all the time and it's normal and nobody comes up and speaks about it. So with the support of VALS and Ellen's, we've got community, we've got mob that let go of the shame of coming and reporting and moving forward with trying to get justice and accountability for what's happened to them that may not happen to anybody else, especially maybe a white fella, but then we don't want to sound racist, do we? I think I'm going to kind of leave that. So what my role mostly comes about, a lot of the work I do is bringing that cultural support, that trust, the bridging between the lawyers and the client, that go-between person. Hence, you'll notice I have George with me today. Now, George is my possum skin given to me by a dear friend. And I find that I bring that with me a lot of where I go, especially when I'm meeting with clients. George is usually out on the table, but we don't have one here today. And you may see this in the Curie Court a lot. There's a lot of things like that. And what George's job is, and he does it well, is to provide comfort, culture and communication for our clients that are going through this process. It's just some of the support that I can provide. Other kinds of support that I'll provide is, as we said, with the case study, meeting with the client, supporting the client throughout the whole process, from explaining things, explaining processes, referring to services, that general kind of stuff. But as you find, each client is individual and they all have individual needs. So I will base my support on what they need and what they're asking for. And a lot of that is found out just through having a yarn. It's not through sitting there ticking off the questions one by one. I mean, that's what they do at the police station. That's what they do in other places. That's not really going to make them comfortable, and you're not going to get the best out of your client. Perfect example is the case study that Alan's was just speaking of. The young client leading up to the day, we're obtaining statements from him, and Elle was doing a great job, you know, going through the questions, this and, you know, A, B, C, whatever it was. And the young person became quite emotional, was crying, having difficulty speaking. So we went outside for a yarn and, you know, we took some time. I took time listening. He was comfortable and explained to me that his uncle had also passed at the hands of the police. And that was sitting with him during the questions that he was being asked by Elle. So enabling that conversation was brought to Elle's attention, and the rest of the interview that preceded went along a lot better, a lot more comfortable. Elle was able to adjust the way that she was and what she was asking him based on the knowledge that she just had found out. So this is something that maybe he wouldn't have been comfortable speaking to a lawyer about. I mean, I know I wouldn't be, you know, and, you know, this just shows the generational trauma that can be handed down from one family to another, whether you know about it or not. Also part of the role is referring to heal or help heal. Sometimes that happens through some conversations with myself, other times specialised counsellors, mob, they will, you know, assist the client, support the client, give them someone to talk to. And you must realise how difficult it is for someone that has been harmed by, you know, the people that rule this place, the people that make the rules, that serve, you know, amongst the hierarchy of this state that we live in, that, it's really difficult for people to come, for mob especially, with all the history and all the racism and everything that them and their ancestors have endured. It's really difficult for them to feel comfortable to say everything. So, the reason I do this role is, my kids, they came home. I'm lucky, I'm blessed, I'm honoured that my mob and community respect me enough to be able to share the most traumatic emotions, times, words with me. And in my own way, that helps me heal. What else would I like to say? I've got so much, I can talk for a while. But I don't know, I think we could go to questions. Yeah? You can tell I'm not an expert. But anyway, I'll pass this back to Harry. Thank you, guys. Question time.
Happy to take any questions if anybody has any.
Hi, is that working? Yeah, hi. I'm Rowan. I am in the police and prison accountability team at NAJA. So we do very similar things, but in the top end and in Central Australia. One of the things, well, everything you said was really interesting, and I think it would be great to have a chat after. But one of the things in particular you mentioned, Elle, was working with grassroots organisations, and civil litigation is just one part of the big project. How do you partner with grassroots organisations and media and stuff like that?
Yeah, sure. Thanks so much for the question. It's a really great question. I guess I'll talk a little bit about our coronial practice, which is a little bit, it's connected to the police accountability work, but I guess one grassroots organisation I can think of is the Dagher Foundation, who support families who have lost loved ones in custody or with police. And I guess we have mutual clients with them, so they provide support for our clients who are going through the coronial process. They might be able to help with media support, fundraisers, I guess that kind of inside support that I, as a lawyer, can't provide my client because I haven't personally been through that process and I don't know what that feels like. I can empathise with that and I can have compassion for that, but I haven't been through it myself. So it's that real, I guess, that sort of support that they provide. In terms of, I guess, broader campaigns and broader advocacy, I think we would look at what's happening on the ground before deciding ourselves to, run a campaign or do advocacy on a certain issue. So independent police oversight is an issue that has been pushed in Victoria by countless organisations, and the Police Ombudsman Now campaign, which VALS is a part of, grew out of, I guess, that community groundswell and community needs. I've answered that sufficiently. Jo, did you want to add anything? Yeah.
Okay, my name's Fabian. I'm a Noongar man in my third year of law. My current legal situation is his mother's been telling me that he's innocent of a crime and the police wrongly investigated it. Also, there's another problem. The courts is taking extremely long time. Legal aid, they've been adjourning for a couple of years. my son has got an intellectual disability, and the Supreme Court has downgraded that charge to a magistrate's offence now, but because he's been into the Supreme Court, he's been charged for that. Also, there's no legal problem at the moment, or so they say. There's no bail application, and also he's not on remand. All they're doing is warehousing him, waiting for NDIS funding and NDIS accommodation. I have written to your organisation a couple of weeks ago. I haven't heard anything back from it. I've been letting his white mother dealing with it for a few years. She's had no luck. Because she's had no luck, she's actually signed over the guardianship to the Victorian Advocate, and the Victorian Advocate now has sacked the NDIS case manager now, but that person wasn't doing any good. And she tells me every year NDIS is renewed, but someone else is telling me something different. They have to do more assessments, more reports, because they feel if he goes into the community now, he's a risk to the public because of what happened. My question is, can you look into this? Get my son out of Port Phillip jail. He's been in 3 jails here for 4 years. Hasn't been sentenced. He's not on bail. He's not on remand. Nothing at all. And the Supreme Court said he was unable to plead. So what I'm asking for is we go back to the Supreme Court in February next year. Can you look into this case and find out what is NDIS is doing? Why are the lawyers adjourning for the last 2 years? And guess what's going to happen again? We'll go back in February. It's going to be adjourned because it's not rocket science, because they haven't done the reports. I'm not sure what NDIS is doing. And also he needs to get accommodation. He can't go back to his mother's house, but she can't look after him at the moment. And I can't take him back home because he's under the Victorian guardian. I'd like to take him home, but legally I can't at the moment. So what can you do to help me in my situation? Because I've been here for 3 weeks and trying to get information. I've been able to see him twice. Can't get any information from the lawyers, can't get any information from the Victorian Advocate. I can't get any information from the Supreme Court. I really have little information going at the moment, nothing at all. And apparently my son's mother tells me he's innocent of this crime. They more or less framed him in this sort of instance. So how can you help me in that situation?
Thanks so much for your question and for sharing that. That sounds like an incredibly difficult, frustrating and challenging situation. I think maybe the best thing is for us to have a bit of a chat outside, maybe with one of the criminal lawyers from VALS who are here today, and we can have a bit more of a chat about it, find out some more information, and try to assist you. Getting NDIS support in prison is notoriously difficult. It's almost non-existent, and Port Phillip Prison especially is notoriously bad. So I hear your frustrations, the delays as well, really, really difficult. Let's have a chat about it outside after this, and we can try to get you some support from VALS.
There were lots of hands that went up before. Are there any questions? And that is a classic example of the frustration and the love of a father in our community willing to fight. So keep fighting for your son. Is there the microphone?
Hi. Thanks to the panel, and thanks, Fabian, for sharing that. I was wondering, just following on from what Fabian said, what proportion of your clients are dealing with police accountability issues and versus prison issues, or is there overlap?
Yeah, there's definitely overlap. I'd say it's probably a 50-50 split. So we haven't spoken much about our prison accountability practice today, but the main sort of work that we do in that space is helping people in prison with their healthcare needs, so advocating for people in custody to have their healthcare needs met. NDIS would be something that we could help with. Mm.
Also, the support workers are prison staff.
Yeah.
And also the support worker, he's not, he doesn't understand what's going on. He's in prison. He's with the worst people for the last 4 years. With the murders and rapists and all these other guys, and he's just, he's like a child.
Mm. That's something that we hear a lot. So 50-50 split, but we do, people come into custody, they might be withdrawing or go from police custody into prison custody. They might not receive adequate healthcare at either stage, and they might also come into custody with injuries caused by police. So there's an overlap there, certainly, of all those different issues.
Thank you. Did that
just over here.
Yep.
With the Freedom of Information request release for the body-worn camera footage, excuse my ignorance with it, but why is it a guideline for police, or is it legislated that only upon commencing civil proceedings it will be released?
Yeah, so why can't we get body-worn camera under
Yes.
Freedom of Information? Yeah, so the reason is the Surveillance Devices Act, which makes it a criminal offence to share or release body-worn camera footage unless it falls into one of the prescribed purposes. So previously, civil litigation wasn't one of those purposes. Some of the purposes are like criminal proceedings. Everybody knows that body-worn camera footage can be used as evidence against somebody. It could be used for things like education and training and a few other purposes. And then there was a civil case in 2022, case of German, and body-worn camera footage wasn't able to be admitted into evidence in that case, and there was some legislative reform following that, which now allows body-worn camera footage to be used in civil proceedings. We take the view that that should mean preparing for civil litigation. So if we submit a Freedom of Information request and we say we need to look at this because we want to investigate whether this client has a claim, Victoria Police take the view that that still doesn't fall into that exception, that the civil proceedings need to be on foot before they will share it with us. They take the view that it would be a criminal offence for them to share it with us under Freedom of Information, which is really absurd and goes against the purpose of those reforms. And I will also say, you're actually kind of lucky to get to that stage. So the statutory deadline for FOI in Victoria, I think, is 28 days, but there's delays of up to 12 to 18 months to get material under FOI. So we don't really bother with it anymore. No, they won't. They take the view that they would be breaking the law by providing it to us. So I guess we go and, we can go and view it at the police station. I guess if there are criminal proceedings on foot, the easiest way for us to access it is through the criminal brief. And that's often how we view it.
Thank you. I mean, it makes sense. It doesn't make sense why you're frustrated and we're frustrated that we can't see it. Yeah. So just a question at the front.
Just a quick follow-on question from that, I guess. I'm really interested about the body-worn footage and what's happening here in Naarm. How long do police have to retain the footage for? What window do you have to be getting civil litigation on foot?
So it depends. So
Classic.
Again, classic, yeah. Classic lawyer answer. So it depends. If it's linked to a criminal offence, then that's, I guess there's a statutory guideline of how long it needs to be kept. So, for example, footage relating to family violence, I believe, has to be kept for 50 years. It's quite a long time. And then, depending on whether something is a summary or indictable offence, there's different rules. Often we're not so worried about the footage being deleted unless there were no criminal charges. Then in that case, we might be. But the first thing we'll do when speaking to a client is sending out a preservation request to have footage retained. So even if we haven't formed a view or whether that client has a claim or not, we'll send out a request asking police to preserve the footage. Generally, they do, and we'll refer to the Crimes Act saying, it's a criminal offence to delete footage that you've been put on notice is likely or might be used in a civil proceeding.
Follow-up question. Thank you, Elle. So hang on, what am I thinking? Clients that take a while to, sometimes takes a long time to come forward and talk about what's happened with police and all the shame and stuff you were talking about, Aunty Jo, before. Just so if there's that, delay in clients coming to obtain legal advice or issues with access to justice as well, which we know is ongoing everywhere, what's the time limit there? Do you know?
For the footage, or to bring
how
a
long they
claim?
have to retain it for? So if a client comes to you in 12 months after a police incident, and then you want the footage, and you send the preservation request, will they still have it, or has it already been wiped? Like in New South Wales, it's like 6 months if no incident's been reported, right? I think.
Yeah, I think that's right in New South Wales. I'm trying to think.
Sorry, Elle.
No, that's okay.
I'm into it.
Let me have a look. I can't remember off the top of my head exactly what it is if it's not linked to a criminal brief or criminal charges. I'll look into that, Gail, and get back to you. Can't remember off the top of my head, but generally we find that's exactly right. Clients might not come to us for a while after it's happened. Yeah. Most of the time the footage is still there. CCTV footage, not so much. That's 6 months. Most of the time the footage is still there. It's more if the body-worn camera isn't turned on to begin with, then that's an issue. And that's an entirely separate issue that happens as well. Or it's turned on and off during an interaction, or the sound's muted for a part of the interaction. That's an issue we see a lot, and that's really, really hard. That's a real challenge.
Thank you.
Absolutely heartbreaking to hear. Does we have time for one last question, or are we good? Does everyone's hand? I think there's one last one. Thank you.
Hi guys. Just following up on those questions, as you say, it might take some time for clients to come forward and tell their stories, and we've got all these barriers to getting information from police. What advice would you have for criminal lawyers who might be in the room that they might see police accountability issues come up in their work? How could they preserve the rights for their clients to do civil litigation later, or, yeah.
Thanks, Serena. I'm happy to take this. So that's a great question. Criminal lawyers who might have a client that's got visible injuries or tells you about visible injuries, taking photos of those injuries yourself or getting your client to. If they're not in custody, getting them to seek medical attention for those injuries as soon as possible. If they are in custody, perhaps making, and they've tried to seek medical attention and they haven't been able to, making a request to the prison that they be provided with that medical treatment as soon as possible. Getting the footage through the criminal brief. So I know I'm not a criminal lawyer, but I understand material will come through in dribs and drabs. You might not get everything all at once or at the start or before the contest mention, but making sure that you're really pushing for that body-worn camera footage and making sure that you've got all the body-worn camera footage available. So, you know, having a look, how many officers were there? You know, do we have footage for every individual officer that was there? And really pushing for that, because we may not be able to get it later because of the issues with freedom of information. What else? I guess sending off subpoenas if you think that there's footage that isn't in the brief that is relevant, seeing whether there were any witnesses to the incident that your client might know about, family members, was anybody there, did anybody record the incident, trying to get that information out, that you know you can film police, you're entitled to do so, you're within your rights to do so. Understand why people don't. It can be really confrontational and people don't want to make an already, you know, awful situation even more intense. But yeah, making sure clients are aware of that. And if you have an Aboriginal or Torres Strait Islander client, you can refer them to our team as well. Or chat to us. We're always happy to chat about these matters at an early stage.